Welcome to this session on international humanitarian law, the laws of armed conflict, and iron swords, the current conflict between Israel and Hamas in the Gaza Strip. My name is Ido Rosenzweig. I'm the chairperson of ALMA, Association for the Promotion of International Humanitarian Law, and Director of Research of Terrorism, Belligerency, and Cyber at the Minerva Center for the Rule of Law Under Extreme Conditions at the University of Haifa. What we are going to do today is a talk about the laws of war, international humanitarian law, and its applicability towards the current conflict. Now, the audience in this session is quite diverse. Some people have extensive knowledge in international humanitarian law, and some people don't, well, basically are normal and they don't really know that body of law. And what I plan to do is to accommodate both groups by going part by part into international humanitarian law, into the laws of armed conflict. And within each section, I'm going to make references where relevant to the current conflict and current events, and to see where it is relevant and where is it not relevant. And at the end of it, I will actually address the relevant issues. And I will address the relevant issues of the conflict, and from that, I will address eventually the questions that some of you have submitted when you registered. And to that extent, where things won't be answered, we will have a Q&A session where we can have it all addressed. So these are the topics of interest that I am going to try to touch throughout this presentation, starting with the horrible events, the horrific events of October 7th, the question of the status of hostages, things related to siege or blockade, question of occupation of the Gaza Strip, the notice to evacuate the north of Gaza and asking civilians to go to the south of Gaza, attacking hospitals and ambulances, proportionality in general, the relevancy of human shields to that. Classification of conflict has been a very interesting topic that many of you actually asked about. International criminal law, which includes war crimes as well, crimes against humanity and genocide, and different aspects. The recent attacks on the region of Jabalia, where there was considerably a significant amount of casualties within a short period of time. And lastly, within that list, the issue of expressions of politicians, where sometimes we think that are relevant, sometimes they are not relevant. Really depends who you're asking, who makes that reference. I will make one small caveat or warning before I actually start, and that there is a certain chance that there will be a siren if rockets are launched at where I'm placed. And in that case, I will have to take a 10-minute break, go to a safe room, and then I will return. I will let you know if something like that happens, and hopefully it won't happen, and we can do the full session without any interruptions. So let's begin at the beginning. The legality of the use of force is a big question, which is differentiate with whether or not parties to the conflict actually follow the laws of war, international humanitarian law. First of all, we have the question of whether or not a state is allowed to use force. And the question of the legality of the use of force is what we refer to as the jus ad bellum, which is separated from the jus in vogue, the laws of war, and it's more focused on whether or not the state is allowed to use force. Now, generally speaking, a state is allowed to use force against an armed attack. When there's an armed attack against the state is allowed to use force in self-defense. Now, that reference, that notion is very much embedded in the UN Charter. Article 2.4 of the UN Charter refers to the fact that no state should infringe the territorial safety of another state. And Article 51 of the UN Charter allows to use force in case of self-defense, basically. And the problem with the reference to the UN Charter is that the UN Charter refers to state versus state. So the self-defense of a state from an armed attack by another state or by its proxy at the most. But what happens where the armed attack is by a non-state armed group, such as Hamas towards Israel? And then the UN Charter is not necessarily relevant, but we do have the bigger concept of a self-defense of a state, which is based on a much deeper and a much older concept of self-defense of states, goes back hundreds of years back, if you want, but we also have the newer version, the more recent version of the legitimacy from the international community to the US to use self-defense against the attacks of September 11. And therefore, we can see that under international law, there is recognition of the use of the legality of the use of force under self-defense paradigm against non-state armed groups just as well. The rules of self-defense are that a state is allowed to use force when there is actual necessity to use force against an armed attack, and that response, that use of force, has to be proportionate to the threat imposed by the adversary. And I want to emphasize that a little bit. The proportionality, the question of the self-defense, the response has to be proportionate to the threat, not necessarily to the armed attack that the use of force is replying to, but rather the threat that exists. Now, if we look at the threat that Hamas imposes over Israel, we have the horrific events of October 7. We have thousands of rockets already launched, but also aimed at Israel just as well. And we have statements by heads of Hamas who are saying that they, given the chance, they will repeat the events of October 7 over and over and over again. And that accumulates to a big, a significant level of threat. And therefore, the Israeli response, which is aimed to eliminate that threat, is, in my view, proportionate to the threat. And then from that point on, we do have that ongoing armed conflict between Israel and Hamas. Now, I should note that there are two other ways to analyze the situation. One of them is that the question of the legality of the use of force is no longer relevant, because Israel and Hamas have been in an ongoing armed conflict for the last, since, let's say, 2007, give or take, or 2009, at the end of 2008 with Operation Cast Lead. But ever since then, we have higher threshold or lower threshold intensity of the same armed conflict. And once an armed conflict is ongoing, question of on the legality of the use of force become irrelevant. Another alternative is the reference to whether or not Gaza is under Israeli occupation. Now, we have a statement made by the International Court of Justice saying that since Israel is occupying force, it has no right to self-defense against armed violent resistance or armed groups within that occupied territory. Now, while it might say that there is no right to self-defense within that framework, as occupying power, if we subscribe to that paradigm, the occupying power has the responsibility and has the legitimacy to use force against for its own protection, and for the protection of the civilian population within that region. So either way, how we look at it, whether there is a question of the use of bellum, question of the legality of the use of force, or question there is an ongoing armed conflict, or Gaza is occupied by Israel, then Israel has the legitimacy to use force under those circumstances. So as we look at if we want to put things in perspective, on October 7th, which hopefully we are all aware of the facts, but I will mention it just to be on the safe side. On October 7th, thousands of Hamas fighters infiltrated into Israel and attacked a lot of civilians, a large group of civilians, killing 1,400 civilians approximately, and injuring, I think, 5,000, 7,000 more. And they also abducted and took hostage 240 Israeli citizens, along with several more foreign citizens with them. So that entire framework constitutes that armed attack that has begun everything. So within that framework of the legality of the use of force, I believe that it is quite straightforward that Israel has the right to defend itself, or at least the right to use force in that situation. And that leads us to the question of the actual use of force, how Israel uses force, or Hamas is using force within that conflict. Now, international humanitarian law, which is the same name as the laws of armed conflict, completely the same name, the same body of law. Its essence is to regulate the armed conflict while minimizing collateral damage. So the idea is that to allow the parties to the conflict to use force in a regulated way, but minimize the harm mainly to the civilian population, but to some extent also to the armed forces that are fighting. Application of international humanitarian law is only during armed conflict, and it is crucial to understand that the legality of the use of force is completely irrelevant to how you use force during an armed conflict. So who is the just side to the conflict, who had the right to self-defense or the right to use force, is an irrelevant question to whether or not you should follow international humanitarian law, or IHL in short, because the main idea is that we don't want that to be dependent, because if we do make that dependency, we will lose any chance to maintain the regulation of the armed conflict, and therefore these questions are completely separate from each other. Another application, another aspect is the notion of no reciprocity. No reciprocity means that if one side to the conflict violates international humanitarian law, that does not provide any permission to its adversary to violate international humanitarian law. The fact that one side attacks civilians, Hamas is attacking civilians, or use indiscriminate rockets towards the Israeli population, does not provide the IDF, the Israeli Defense Forces, any legitimacy to avoid or retract from their obligations under international humanitarian law, and every operation has to be the fullest in accordance with international humanitarian law. The sources of international humanitarian law goes way back, and it's definitely not only under the code word of the Geneva Conventions. We go back to the Martens Clause, we have the Hague regulations, but we also have newer sources, just like the additional protocols of 1977. And to be more accurate, most of the relevant parts of international humanitarian law, the definition of military objective, the definition of a combatant and a civilian, the notion of proportionality and the notion of precautions, and all of these aspects are actually embedded within the 1977 additional protocols. Now, interestingly, Israel is not part of the additional protocols, but that doesn't make it any less relevant, because the notion of customary international humanitarian law means that Israel is obliged by entire body of international humanitarian law, or more accurately, the customary rules of international humanitarian law. Customary rules are the rules that all states have agreed to apply by, even if they are not party to a relevant convention or protocol. And Israel has stated over and over again that it sees itself obliged by the customary norms of international humanitarian law, and therefore everything I'm going to relate to in this presentation is going to be within the concept of either it's embedded in the 1949 Geneva Conventions, or it is customary international humanitarian law, and therefore relevant and applicable to our conflict. Now, we usually divide conflicts to either international conflict or non-international conflict. International armed conflict is traditionally viewed as a conflict between states, and non-international conflict is referred to as between state and a non-state actor, usually, or between non-state actors among themselves. There is a big question: what is the classification of the armed conflict between Israel and Hamas? Because on the one hand, it's not state versus state. On the other hand, it is a cross-border conflict and not a state versus internal armed group within its own borders. So there are discussions, there are different opinions. In 2006, the Israel Supreme Court, the High Court of Justice, ruled that the conflict between Israel and Hamas is an international conflict because it is a cross-border conflict. And from that point on, Israel and the IDF are working under the paradigm that this is an international armed conflict. However, to simplify things, I don't really think that it really matters, because the customary norms, which I referred to earlier, relevant both to international and non-international conflict, and therefore the question of classification is not that relevant. It could have been relevant in the case of the notion of prisoners of war, soldiers or combatants falling at the hand of the enemy are supposed to receive prisoners of war status. However, because the adversary is a non-state armed group and not a state, there is no concept of prisoners of war. And a lot of the safeguards that are applicable to international armed conflict are relevant within a conflict between state versus state and not relevant to state versus a non-state armed group. And therefore, all the hostages that are held by Hamas, whether they are civilian or combatants, are to be considered as hostages and not as prisoners of war or any sort of things. And to be frank, they have to be released immediately and unconditionally. And pending their release, they should receive all the humanitarian treatment that any hostage should receive. And the mere fact that they are being held hostage is a violation of international humanitarian law and international criminal law to begin with. Yeah. So the basic principles of international humanitarian law are military necessity, distinction, proportionality, and humanity. These principles are the basis. They are the notion that creates international humanitarian law. And if you understand those four basic principles, then you understand the logic of international humanitarian law. You understand how it thinks, you understand how it works, and you can almost understand everything and analyze everything within or on the basis of those principles. So I will start with military necessity. Distinction will come next. Military necessity means that you are allowed to use force in a manner that for anything that allows you to achieve your military goals. So if you have military necessity towards a legitimate goal, you are allowed to use force. Now, the big question is what constitutes a legitimate goal? A legitimate goal in an armed conflict is basically to win the war by weakening your enemy and bringing it to surrender. Well, an illegitimate military goal is the occupation of a land, the complete destruction or annihilation of the Gaza Strip would be an illegitimate goal. Beating Hamas would definitely be a legitimate military goal because this is your adversary. The civilian population of Gaza Strip is not the relevant enemy. So the notion of you have to do anything, you're allowed to do anything that promotes those military goals, those legitimate military goals, are what frames under military necessity, but it's not a very restrictive rule. And this is where the other three basic principles come into play. And probably one of the most important within them is the notion of distinction. Now, distinction was referred to many, many times as the heart, the core of international humanitarian law, and it holds two main important aspects. One, I refer to as the positive aspect. You have to take actions to distinguish between your combatants and military objects and fighters and the civilian population. And you can see that usually militaries are doing that by using forms and using uniforms and placing their military bases away from the civilian population to the possible extent. The negative aspect is to avoid from conducting direct attacks against civilians. So I'm only allowed to conduct direct attacks against military objectives, against military targets. I'm not allowed to do, under the distinction principle, to conduct attacks, direct attacks against the civilian population. The civilian population is protected from direct attacks, and I'm not allowed to attack them directly. And this is the most basic notion of the principle of the distinction. Now we can see just from the beginning that Hamas, by its modus operandi, is violating the principle of distinction. It attacks civilians directly. We can see that perfectly well on October 7th events, but also it attacks indiscriminately by firing rockets, which cannot be directly aimed at military targets, but they don't even try to direct them at military targets. So they violate both the positive aspect and the negative aspect of distinction by also placing themselves within the civilian population and in accordance to IDF spokesperson, even within and under hospitals, etc. So the whole notion of distinction is strictly violated by the Hamas, but as we said a few slides ago, the fact that one side violates international humanitarian law does not provide legitimacy for the IDF to violate as well, and therefore the IDF must maintain its operation in accordance to the principle of distinction. Now, I said that civilians are protected from direct attack. Civilians lose that protection if they take direct part in the hostilities. Once they take direct part in the hostilities, they bear arms or they provide substantial contribution to the Hamas in that case, those civilians lose their protection from direct attack. Same goes with objects. Houses and cars, etc., can lose their protection as a civilian object once they become military objectives. And military objectives have, you can see in this quote from the additional protocol, that there are two main tests to what constitutes a military objective. One, an object which by its nature, location, purpose, or use make an effective contribution to the military action, and its destruction offers definite military advantage. If both tests are fulfilled, this is a military object and it allowed to be destroyed or directly attacked. So the nature, location, purpose, or use is usually where we put the focus on when we try to analyze whether or not a specific object is civilian or military. Now, if there is a question, there is a doubt whether or not a specific object is military or civilian, that benefit of doubt is always in favor of civilian, in favor of the protection, and not towards the attack or towards the becoming a military object. As a result, private houses and schools, hospitals and ambulances, and religious places are considered civilian objects. On the other hand, a tank will be considered a military objective. A military base, by its nature, just like a tank, would be a military objective, just like a location for a potential location for a sniper might be considered by its location as a military objective. And it goes the same with if we use a private house or school, if we use a synagogue or a mosque for military purposes, if we shoot from that direction, or if we store our ammunition within that place, that place loses its protection. Hospital and ambulances have some differentiation. They can lose their main protection just as well, but it is important to understand that they do have special protection under international humanitarian law, and even if and when they lose such protection, they still have some additional protections and some other levels of protection because of their important role to the as medical facilities. Now, the fact that I'm allowed to use and directly attack military objectives does not end the story at that point. So even if I'm allowed to attack a specific objective, I still need to make sure that when I attack it, I don't cause excessive damage to the civilian population. And that falls within the third principle, the principle of proportionality. The principle of proportionality is by far the most, in my view, the most complicated principle of all four, and probably the most important one, the one we hear the most about. The notion of proportionality, on the one hand, it is a little bit complicated to understand at first, but once you understand it, you basically understand the entire framework of the four principles. So in a way, all four principles are embedded within the notion of proportionality, and I will try to explain how it works in an organized way. So I'm allowed to attack a military objective, even if that attack is going to cause the death or the harm to uninvolved civilians. That harm to uninvolved civilians is defined as collateral damage. I'm allowed to cause collateral damage, even knowingly cause collateral damage, as long as the damage is not disproportionate damage. So what does it mean, disproportionate damage? Disproportionate damage means that the expected damage to the civilian population, the expected collateral damage, is not excessive in comparison to the direct and concrete military advantage from that same attack. Again, the expected collateral damage versus the anticipated military advantage. Okay, I need to compare them both, and only if the collateral damage is excessive towards the concrete and direct military advantage, only then the operation will be considered as disproportionate. Let's take it step by step. Now, clearly it's very difficult to compare both aspects. It is very difficult to compare military advantage, which is not necessarily a numeric value, versus the damage, the collateral damage, which is usually estimated with number of casualties and facilities destroyed. So I need to compare between them, and therefore it's not a numeric comparison, it's more of an evaluation. Now that evaluation is not made by the legal advisor and not made by the politicians or the cabinet or whatever. That evaluation is conducted by the military commander. The military commander has the knowledge, has the expertise, has the experience to make such an evaluation, and only the military commander is allowed to make that analysis. Now, another aspect is, if we look back and see, we're talking about the expected to cause collateral damage, the expected, and the anticipated military advantage. Therefore, we look at what we knew before, not at the ex post facto outcome. We don't look at what happened at the end. We look at what the military commander knew or should have known at the time of the attack. And that is very, very important, because if I, as a military commander, use all the intelligence in my ability under the circumstances, and I understand that the expected collateral damage is of 10 civilians, I say, okay, in comparison to the military advantage, this seems not excessive, and I approve the operation, and then the outcome is that my intelligence wasn't that accurate eventually, and 20 civilians are there and they are harmed by the attack that I approved. Now, I want to add that if I had known that 20 civilians are going to be there, I would have said that, no, this is disproportionate. I would not have approved that. So 10 civilians are okay, 20 civilians is too much and would be excessive in my view. Under international humanitarian law, I need to be evaluated in accordance to my decision with regard to the 10 expected civilians, and not the actual 20 that were there. And I want to emphasize that point, because what we usually read in the papers, what we see in the website and social media, is the actual outcome, the ex post facto outcome of the attack. We don't know what was the anticipated military advantage. We don't know what was the expected collateral damage from that attack, what the IDF or the specific military commander had in mind and had when the operation was approved in front of them. So using the ex post facto outcome to evaluate whether or not an attack was proportionate or disproportionate is jumping to conclusions in a big sense. And this is something that we should be very cautious about, because we don't have the full information. And sometimes we ought to ask for more information. We should ask for the IDF maybe to provide more information. We should ask the IDF conduct an inquiry or investigation of that attack. But it is professionally impossible to jump into the conclusion that a violation of international humanitarian law has been committed and a disproportionate attack has been conducted if we don't have the full information. Concrete and direct military advantage is also a question that has been the subject of several discussions. Should we calculate concrete and direct military advantage on every shot fired, every rocket from an airplane, or should we look at the broader sense, more of a complete set of attacks or the complete conflict? Just might as well. So usually the answer would be, as any common lawyer would say on almost any common question, it depends. If we are talking about attacks from airstrikes, then I would say yes, every airstrike, every missile should be conducted in accordance to the proportionality on its own. But when you send ground forces to fight within the streets of Gaza, you can't really calculate every shot fired, and you have to look at it in a broader sense, but definitely not the entire conflict. So it's really a question in a sense of whether or not the type of the situation that we are within, and whether or not it is feasible to make such an evaluation with regard to each and every attack. Now, the question of excessive is a very interesting one, and I've actually tried to visualize it in a sense, and I want to try that visualization with you. It's a very low-tech version of what I would imagine we can do to explain what excessive means, but I hope that you understand how it works and why I'm using that kind of method. So if we use the blue line as the military advantage, and we use the green line as the collateral damage, I would say on that the collateral damage is definitely not excessive towards the military advantage from that attack. Now, in the second example, again, the blue line is military advantage and the green line is collateral damage. You can see that on purpose, I even place the collateral damage a little bit higher than the military advantage. In my view, even if they are equal or a little bit more collateral damage than military advantage, this is still not excessive. When it would be excessive when it is clear, it's obvious, and there is no doubt that the collateral damage was excessive towards the military advantage. This is when and where we are talking about excessive collateral damage. Now, when we understand that notion, we have to take into account the next principle, the principle of precautions. I jumped through the notion of that little example that I had about the fact that there are different ways and different perspectives to show whether or not an aspect, an attack was excessive or not, and the notion of collateral damage and comparison within military advantage and collateral damage could be defined in ways user sensitive. Some people can define collateral damage in different ways and to make them look as they were excessive even when they were not that excessive. And we should be very cautious when we're talking about whether or not an attack was actually disproportionate or proportionate just as well. So the principle of precautions. The notion behind the principle of precautions is, if you remember when I said what is the main essence of international humanitarian law, the main essence is to regulate the use of force while minimizing collateral damage. Precautions are doing exactly that, the second part. They're trying to minimize collateral damage to the feasible extent. So you have to do anything feasible, and feasible is a key word here, to limit the harm to civilians, to minimize, to avoid or to minimize collateral damage from attacks. And it means, of course, implementation of the distinction principle and applicability of the proportionality principle, but it also requires to use the most accurate weapon available under the circumstances. And under the circumstances is very important because you don't always have to use the most expensive weapon that you own, but all things considered equal, if you have the possibility, you have to use the most accurate weapon, the one that will minimize collateral damage or completely avoid from collateral damage if you can. Another aspect is the notion of effective advance warning. So we hear a lot within this conflict, within the practice of the IDF, about the use of advance warning, about throwing leaflets, phone calls, SMS, text messages, radio notifications, and TV notifications, etc., aimed to warn people or civilians, uninvolved civilians, to stay away from any area that is about to attack. Now, the IDF is not doing that because it is a more military or because it cares more about civilians than any other armed force. IDF is doing that because this is an obligation under international humanitarian law to provide an effective advance warning before an attack that is expected to harm civilians. Within that notion, there is a big discussion of what actually constitutes an effective advance warning, with the emphasis on effective. Now we've heard that the IDF issued a call for the people who are living in the north of the Gaza Strip and mainly the north of Gaza City to move towards the south part of Gaza. And there was a big discussion whether or not that warning is a forced deportation or an advance warning or any other aspect of feasible precautions. Now, it's a question of intent. The intent of the party, the intent of the IDF while doing that is what constitutes the big question of whether or not that warning, if it's a warning or just a precaution tool to a civilian population, was legitimate or not. Regardless, it's important to understand that the use of that advance warning does not provide the IDF any permission to violate the principles and the rules of international humanitarian law. You cannot assume that everyone who had left in the north of Gaza is taking direct part in the hostilities. You cannot assume that they are willing to support the Hamas, and you are not allowed to assume that they are not collateral damage. They are still, if they are civilians, they are still protected from direct attack, and they are still considered collateral damage. Lastly, about advance warning. Advance warning is mandatory with one exception: if the circumstances don't allow it. If the circumstances don't allow to provide an advance warning, then you are exempt from using it, and that exemption is usually reflected in two main examples. One is a surprise attack. Then if you actually have a necessity for a surprise attack, providing an advance warning would undermine that attack, and therefore it won't be relevant under the circumstances. And the other one is responsive shooting. If someone is shooting at your direction, you're allowed to immediately respond and shoot towards them. Now, there is an exception to that exception, and that double exception is with regard to hospitals. Hospitals are specially protected objects, and any attack against a hospital must be only when the hospital is considered a military objective. Therefore, we go back to the notion of nature, location, purpose, or use. But if you want to attack a hospital, you have to give an advance warning, effective advance warning before that attack. Meaning, you have to give an advance warning that will either allow the party, to the adversary, to stop using that hospital for military purposes, or allow the medical staff and the patients and maybe also the equipment to be evacuated from the hospital so they won't be harmed. Having said that, again, even the fact that you give and provide advance warning to the hospital with enough time to evacuate does not mean that everyone who had left in the hospital becomes a legitimate target. They are still, if they are uninvolved civilians, they are protected from direct attack, and they would be considered as collateral damage. And this becomes very interesting in the context of the Iron Swords conflict, because the IDF has provided repeated warnings to hospitals to evacuate. They provided warnings to the people from North Gaza to evacuate to the south of Gaza, and it is trying to give more than just 24 hours as was deemed at the beginning. That is the only time that the IDF provides to people to evacuate or to evacuate hospitals or the north of Gaza. It actually provided them more than a week to do so. It is a question of whether or not that would constitute enough as an effective advance warning, and how much time should be between that advance warning and actual attacking a hospital, and what would be the consequences of attacking such a hospital under these circumstances. Yeah. So that brings me to the next notion. So we've done the whole 4 principles of international humanitarian law. Hopefully you understand them well, and they answered at least some of your questions about how international humanitarian law applies to the conflict right now. But there are violations of international humanitarian law. There are clear violations, and they are suggested violations or suspicions or questions of violations of international humanitarian law. And we can definitely divide them. On the one hand, we have violations that are clear-cut. There are blatant violations of international humanitarian law, and these are mainly the events of October 7. They were clear-cut violations of international humanitarian law. They were war crimes. They were grave breaches of the Geneva Conventions, the additional protocols, and therefore they constitute war crimes because they were direct attacks against civilians. There were actions there that including sexual violence and directly attacking the people at the nature party and going from house to house and deliberately attacking civilians. taking of hostage is also a grave violation of international humanitarian law, and all of these aspects are definitely grave violations of international humanitarian law, and they are war crimes. Another type of crime under international law would be crimes against humanity, which are meaning the systematic and intentional violation and massive violation of conducting certain violations, and that constitute crimes against humanity. And those crimes against humanity include, among other things, apart from the sexual violence, also the abduction of the Israelis into the Gaza Strip and holding them as enforced disappearance. Enforced disappearance constitute also a crime against humanity. And the third type of international crime is the crime of genocide, which the events of October 7 are also could definitely be analyzed as fulfilling both the technical definitions of the crime and the intent of committing genocide and violation on a national or religious basis. Now, on the Israeli side, one could argue that there are certain suspicions of violations of international humanitarian law. As we talked before, there are the questions of proportionality, and some aspects, some questions of proportionality might be relevant following the attacks of the IDF. But as I said before, we don't have enough information to conclude that war crimes were committed. We need more information, and we should ask the IDF to provide that information, that kind of explanation of why those targets were chosen as military targets, what was the expected military advantage or the expected collateral damage and the anticipated military advantage from those attacks, in order to make sure that no violation took place, or in case that the violation actually had taken place, then to require that the IDF would inquire, investigate, and prosecute in those situations. Other types of violations could be with regard to the siege that IDF is conducting towards against Hamas. If one would argue that the siege is a legitimate mode of operation, it has rules to make sure that it is legitimate. One of those rules is that the siege has to be conducted against the adversary and not against the civilian population. So the purpose is to attack Hamas and not to starve the civilian population. So if the purpose is to starve the civilian population in order for them to put pressure on the Hamas, that would be an illegitimate type of siege. Just as well, the IDF is obliged to allow the entrance of humanitarian aid into the Gaza Strip in order to minimize the harm to the civilians under the siege. And that means that food, water, and medical supply must be allowed to enter. Now, Israel doesn't have to provide it on its own, but it has to allow humanitarian organizations such as the International Committee of the Red Cross, the ICRC, to transfer such supply into the Gaza Strip. A big question is regard to the first days where IDF and the Israeli politicians announced that nothing will be allowed to enter into the Gaza Strip. And later on, they allowed humanitarian aid, food and water, but they still don't allow to enter gas or fuel into the Gaza Strip because they fear that Hamas will take control over that. And this is where the discussion becomes a bit interesting and complicated, because there are claims that throughout time the notion of fuel has become indispensable for the existence of the civilian population, and hospitals need fuel to run generators. But on the other hand, the strict law, if I remember correctly, Article 23 of the Fourth Geneva Convention refers to food, water, and medical supply. So it has become a question of interpretation. So what can be done with regard to violations of international humanitarian law? International humanitarian law on its own doesn't have any enforcement tools, doesn't have any teeth to maintain and ensure that violations are respected and maintained and punished by the states. The state has the responsibility to do it on its own forces, and a state has a state responsibility for its violation of international humanitarian law. Unlike international criminal law, which is focused on individuals who have actually committed the violations of international law, in the case that we're talking about international humanitarian law. So in the case of a war crime, all states have the ability to indict and prosecute for violations of international humanitarian law within their territory. So they can analyze and they can prosecute for violations under the notion of universal jurisdiction, which means that they can actually prosecute violations that took place outside of its territory and even not by its own civilians or citizens, even if the victim or the perpetrator weren't relevant, weren't connected to that state. That's the notion of universal jurisdiction. And at the same time, the International Criminal Court, the ICC, sitting in The Hague, also has some level of jurisdiction over that matter. The International Criminal Court was established at the end of the 20th century with the purpose to make sure that grave and severe violations of international law, such as war crimes, crimes against humanity, and genocide, are not being overlooked by states. And when states are either unwilling or unable to prosecute on their own, then the International Criminal Court will operate if it has jurisdiction over that matter. And that if it has jurisdiction is a big question in our context, because in 2015, the Palestinians gave jurisdiction to the International Criminal Court over its territory. And that means that although Israel objects that notion, from the perspective of the ICC, it has jurisdiction, and there is an ongoing investigation by the Office of the Prosecutor towards violations of international law taking place within the territory of the Palestinian state, which is a questionable definition on its own, and violations by citizens of that state, which means all the operations by Hamas, even when they take place within Israel, are under the jurisdiction of that court, which includes the events of October 7. On the other hand, Israel definitely objects that notion of jurisdiction. Israel rejects even the possibility that the Palestinians give that jurisdiction to the court, and therefore Israel does not collaborate and will not collaborate with such an investigation. That does not mean that organizations and private individuals, cannot submit complaints to the office of the prosecutor. And Karim Khan, the prosecutor of the court, has already announced that he will investigate the event starting on October 7th within his jurisdiction in order to verify whether or not war crimes were committed. And as we know, those war crimes, crimes against humanity, and maybe even crime of genocide were committed on October 7th, we can definitely know that within that notion, the ICC and the Office of the Prosecutor should act. But I will retract that and say that the relevancy, in my perspective, of that act is almost non-existent, because the most the ICC could do is to issue arrest warrants against the heads of Hamas, and only if they get arrested, they will be indicted and prosecuted in the ICC. And I have serious doubts if that will happen. And actually, the same goes to universal jurisdiction just as well. I wouldn't put my hopes on that. And the most I will refer to universal jurisdiction by states and the applicability of the ICC is the notion of the declarative aspect of those actions, making sure that people are aware and states are committed to act against Hamas for their violations of international law, for their actions throughout that period, and specifically on October 7th. Now, with regard to Israel, I should also note that the ICC is always the secondary jurisdiction. The main jurisdiction, the first jurisdiction, is for the state, and only if the state is unwilling or unable to fulfill and execute its jurisdiction, the court could have jurisdiction over the matter and we accept the fact that Palestinians gave jurisdiction to the court, which means that the notion which is referred to as the complementarity notion will only apply if Israel fail to investigate and prosecute war crimes that were committed by its own forces. So as long as the IDF and the Israeli judicial system will fulfill its role by conducting professional inquiries, and where it's relevant, do a criminal investigation, and where it's relevant, indict soldiers and commanders for violations of international humanitarian law, that will provide the entire forces protection from any possible indictment by the ICC or arrest warrants by the ICC. And the same notion is also applicable towards the notion of universal jurisdiction. Yeah. So that was the main aspect. I think I covered most of the questions that were brought up in the preliminary question. I will go now through some of the issues just to make sure that I didn't miss any of the relevant topics. So I talked about the events, the horrific events of October 7th. The notion of occupation, I will say a word about that. The notion of occupation, in my view, with regard to the occupation of Gaza, is that the occupation of Gaza ended on September 2005, when Israel completed its disengagement from the Gaza Strip, and by that it ended two of the most important aspects of occupation, which are boots on the ground and effective control. Now, the current events, the recent events, really show that Israel does not have an effective control, or hasn't had effective control over the Gaza Strip for quite a long time. And the notion of boots on the ground was quite clear that did not take place since since September 2005. Why some argue that occupation is still applicable and has been and never ended, even despite the disengagement of the 2005. This is because the IDF and Israel has maintained some level of control over the sea, the air, the borders, and basically the electricity, the gas, the water. Some aspects are relevant to some level of control, are subject to some level of control by Israel. And there is a question of how to refer to that vacuum of Israel has left. There are no boots on the ground, but still has some level of responsibility towards the Gaza Strip, or still has some levels of control over the Gaza Strip. The International Committee of the Red Cross and the UN has defined it as still under belligerent occupation. The ICRC has referred to the notion of functional control, which means that Israel has control over the relevant aspect, that it actually has powers towards the Gaza Strip. So borders and water and fuel, etc., Israel does maintain its control, and therefore it's still occupied. And I'm not alone in this, reject that notion, and I believe that Gaza is not under occupation. An interesting question would be, as a result of the current operations, will Israel regain its effective control? Right now we have boots on the ground, there's no doubt about that. Will Israel regain its effective control towards the Gaza Strip, and therefore occupation will return? At current stage of affairs, it still hasn't happened, but there is a question of whether or not it will happen as the conflict evolves. The status of the hostages are, I think I referred to it, but it's quite clear. They are being held by a non-state armed group, and therefore they are hostages. The mere holding of hostages is both war crime and a crime against humanity, and it's a continuous crime. So every day the crime continues, and it must be stopped. And I think all states and all parties and all organizations should put an emphasis on returning the hostages and releasing the hostages immediately. And I will add on that apart from the 241 hostages that are in the public eye at the moment, there are two more hostages that are, I don't think ignore is the right way, but they should also be considered within that and should be released as well. And these are Isham Said, who is being held in the Gaza Strip for 8 years now, and Avera Mengistu, who is being held by Hamas in the Gaza Strip for 9 years now, and they should also be immediately released. The question of siege and etc. I answered and I talked about, so I won't get in that again. The evacuation to the south, I actually got the pictures of the actual flyers that IDF published, and even a translation of that, that asked the civilians of the Gaza Strip to evacuate to the south side of Wadi Gaza. And it says, for your safety and security, and we will let you know when you can return, further notice. And this is a key point that I think we should emphasize, because the question of return has been a very debated aspect of the occurrences and that notification, because that is a clear signal of whether or not we are talking about forced deportation or forced movement, or are we talking about just a security measure. And I think that throughout the time, we saw that the IDF spokesperson has emphasized about the fact that this is temporary and everyone will be allowed to return to the north of Gaza once the conflict ends. So this is an important aspect of the question whether or not this is forced movement of civilians or just a safety measure. Attacking of ambulances in hospitals, I think I talked about it, as long as they are being used as military objectives. Ambulances are being used to move Hamas fighters from point A to point B. At that point, they are considered military objectives, and hospitals just as well. The only thing is that when you attack a hospital, the collateral damage is not only the people inside it and the damage to the hospital, but also the ability of that hospital to take care of the civilian population after the attack will be significantly diminished at least. And of course, if there is an ability to separate between wings and areas of the hospital, you are not allowed to refer to the hospital as one big military objective. The attack in Jabalia, I refer to that notion in the context of the proportionality and distinction. There is a question whether or not that was proportionate, but there were, according to the IDF spokesperson, Hamas command center in the area, as long as high rank commanders of Hamas, which makes that a very high evaluated military advantage from the attack. And then there is a question of whether or not the proportionality, the collateral damage was proportionate or not towards that military advantage. And that remains to be seen. And I think that the IDF will have to provide information about that attack. And lastly, before I open the floor to more questions and the discussion, statements by politicians is something that I feel very strongly about, because we've heard several, let's call them unwise statements by mainly politicians throughout that conflict. Now, I understand that at the beginning of the conflict, the impact was severe and the reaction was a gut reaction in accordance to the horrific events of October 7th. But a gut feeling should never be the guidance of what we do in the military perspective. And statements like we are going to flatten the Gaza Strip or not rejecting completely the notion of using a nuclear bomb in the Gaza Strip, which is a quote we heard yesterday, and referring to everyone in the Gaza Strip as taking direct part in the hostilities, saying that there are no uninvolved civilians in the area, are definitely not helpful, and they are harming and confusing at least. And I think politicians have to understand that even though they think that they are talking internally and they are talking to their voters or their constituencies, and their goal is to talk to their own audience, even though they know that the IDF doesn't work that way, their statements are important. The statements are heard and evaluated by the international community, and they are actually being used as part of trying to prove that the goal of the IDF, the goal of Israel, the goal of the operation is to attack the civilians in the Gaza Strip and not operating legitimacy and in accordance to international humanitarian law, as at least I hope the IDF intends, and I don't have any information to contradict that, which is an important aspect in my view. So that was the not so short introduction to international humanitarian law within the context of the current conflict. And if you have any additional questions, and by all means, don't try to hold yourself back. If you have questions, if you have thoughts, if you have concerns that you want me to explain or to just express them, please feel free, either write them on the chat or use the hand feature to ask for permission, and we can give you the floor to say. So I think, Susan, please.
Ido, I just want to say what an excellent summary you gave. I think it was an extremely difficult topic, and I'm going to mull over the jus ad bellum issues for days following this. So congratulations on such a balanced and interesting presentation. But I wondered if you might agree with me that this issue of proportionality has often bedeviled humanitarian lawyers as to actually what is a proportionate response. And I'm wondering if, with respect to the hospital and the refugee camp, that arguing that there might be senior Hamas officials, is it still a proportionate attack to kill any number of civilians, to go after a major military functionary that you want to dispose of? So I just wondered what your reaction about that is, because I struggle with this notion of proportionality and have throughout my career.
Yeah, I think the notion of proportionality, as I said during the presentation, is a key notion that it's almost, if you understand that notion, you understand the entire concept of international humanitarian law. And I think it's not by accident that we don't see, and we haven't seen, a lot of indictments on that specific violation so far. And we've had that rule for many, many years. It's not new. We've had it for decades and more than decades in the IHL rulebook. And it's there for a reason, and it's almost impossible to indict on that and to prosecute on that. And one could argue that it is because all militaries fulfill that notion of proportionality. I'm not sure if we would agree on that point, but I think it's very difficult to prove and call that evaluation. And let me just say that in accordance with international criminal law, the test is the reasonable military commander making that decision. And if we look at that reasonable military commander and we say, okay, we've had that Hamas command center in the refugee center, but we also had tunnels underneath that. And if that's a significant location of those tunnels, then the military advantage rises. So that I'm quite sure that, much like in previous conflicts following Operation Cast Lead, especially, and the others, sorry, I forgot the name for a second. Protective Edge, sorry, Protective Edge was the second major one. IDF will publish an inquiry and reports on what actually happened and why they attacked that area and what was in that area, because the main questions, the main targets, the ones that got into the public's eye were answered in previous rounds. So I'm quite certain that the IDF will publish what were actually the targets in the refugee center in Jabalia, and we will be able to evaluate to a certain level whether or not it was legitimate proportionate attack, or should someone actually provide answers. And there is some level of criticism about the IDF ability to investigate itself. We've seen that before. We've also had that internally criticism about that aspect, but at least with regard to the big aspects, the main questions, we usually get answers by the reports of the IDF. Sometimes it takes time, which is unfortunate, but also criminal trial usually takes time. So nothing is going to be immediate here. And the need for that immediate answer in this kind of conflict is really difficult. On the one hand, we've seen that in the rocket that hit the hospital quite at the beginning of the conflict, where IDF was blamed for that attack, and eventually it either claimed or proved that it was a misfire by the Islamic Jihad, and that those 5 hours, that generally in our conflict, 5 hours is not a long time, but within PR world and in social media world, those 5 hours are a lot. And the damage done to the IDF during those 5 hours was significant. But as lawyers, at least, we know that we will have to wait significant amount of time, hopefully not too much of time, but we also know not to jump into conclusions. And that's the important aspect in this situation. Do we have more questions? Yeah, I see on the chat. So thank you so much for your interesting presentation. You classified the conflict as international. Therefore, what will be the status of Hamas and Palestinian Islamic Jihad? Could we say that they belong to Palestine? Actually, thank you, first of all, for the question, Eugene. I didn't classify it as international. I said that the High Court of Justice in Israel classified it as international. I still think that this is a non-international conflict, but I said that it would be irrelevant to the application of international humanitarian law to the situation, because customary norms are applicable either way. Even if we would consider that international conflict, I would not consider either Hamas or the Palestinian Islamic Jihad as military forces of that Palestinian state. They are non-state armed groups, and that means that their fighters are not combatants. They don't have combatancy status. They don't have combatant immunity. And just as well, the people that they are holding are not, especially the soldiers, are not prisoners of war. They are hostages in accordance either to Article 3, the Common Article 3 of the Geneva Conventions, or I forgot which article in Additional Protocol 1, which refer to that specific notion in international armed conflict. So regardless of the classification of the conflict, same IHL customary norms would apply. Bear in mind that Israel is not party to Additional Protocol 1, so regardless, we are operating under customary law. And because this is a non-state armed group, then all the major aspects of Additional Protocol 2, the non-international conflict, would be just as applicable to the situation. I hope it answered your question. Stefan, please.
Yes, thanks, Ido, for kind of disentangling all this huge complex of questions linked to each other. I would like Susan Bro, give an additional remark to this problem of prohibition of excessive damages. I always insist we should be careful about speaking of a general principle of proportionality. It's the idea behind, but humanitarian law deliberately speaks of prohibition of excessive damages, which is a type of a very robust disproportionality. And your remark on prosecution, I think if you look into the Rome Statute, the Statute of the International Criminal Court, it has been so much watered down that I think we will probably never see any successful prosecution of that, except in really extreme cases. But my major point is another one. I think it's difficult to convey the message of this robust rule of prohibition of excessive damages to the general public already in Europe, because it's very much driven by military logic, military necessity, and in societies which are quite of how to call it, very far away from experiences of ongoing armed conflict. It's already there very difficult to convey. And I think it's nearly impossible to convey this logic to emotionalized publics in the Arab world. And not only in the Arab world, also in the Middle Eastern diaspora communities in Germany, you can see. Because there you get always this argument, well, you care about 1,400 people killed by Hamas in Israel, but you don't care about 8,000, I don't know how many, civilians killed in Gaza Strip. You hide that behind the screen of legitimate collateral damages. So that's hypocrisy. I don't buy the argument, because it really is a different kind of, it's a different issue. But in a way, I think that concerns me quite a lot. Israel has lost the propaganda war in the Middle East.
Yeah, I completely agree. And I think this is also part of the modus operandi of both sides. I mean, I won't go necessarily into
no, Hamas really plays with that.
Yeah, and this is Hamas modus operandi. Hamas is using the media, and its operations are meant to cause and to use it on social media and in the news, while the main purpose and the main goal of Israel is the actual fight. So Hamas is using the fight for the PR aspect, and Israel and the IDF main aspect is mainly the actual fight and the purpose and the military goals of it. And that is part of asymmetric warfare in today's world. And I should mention that within that concept, one word that I didn't use in this entire discussion is terrorism. I didn't refer to Hamas and the Islamic Jihad as terrorist organizations, and I didn't refer to the whole notion of terrorism, because under IHL, this is not a relevant term. This is not part of international humanitarian law, while terrorism is part of international law to some extent. It is definitely part of domestic law, and Hamas is defined as terrorist organization in the European Union and in the US, but it hasn't been defined that way by the UN, and part of it is because of the lack of the ability of the international community to actually define and have an agreement on what constitutes terrorist organizations. And although some development to that has taken place following September 11, still it is a very complicated and difficult aspect. And while, just as well mentioned, that there could be some equivalent aspects of IHL and counterterrorism aspects, much as like when you fight Hamas, which is considered a terrorist organization in Israel, it could escalate to an armed conflict. But when a situation is under the threshold of an armed conflict, we're talking about law enforcement operations, which are not part of IHL. And sometimes you can see it the way the IDF approaches some of the operations, because if we see the IDF using mainly in the West Bank riot control agents such as tear gas, then we know that according to the IDF at least, or we assume, that this is a law enforcement situation, because the use of tear gas is strictly prohibited under IHL as an illegal type of weapon. And therefore, we have these two equivalent sets of rules that operates, and if we add belligerent occupation to that scenario, we have a complete mess of law, and we need to be very, very strict on what each operation constitutes. But if we talk strictly international humanitarian law, terrorism is not part of it. And therefore, I didn't even mention the fact that Hamas and the Palestinian Islamic Jihad are terrorist organizations. I saw a question by Terence about the ceasefire and humanitarian corridor, etc. And this is the big question, by the way. It's a major question because in order to have a genuine humanitarian corridor, you usually need the agreements of both sides. And currently, the IDF is unwilling to give anything towards Hamas. And at the same time, it seems that the IDF is trying to create a humanitarian corridor to allow civilians to go from the north to the south. And in the south, I think slowly, maybe too slowly, but slowly, there is a development of a field hospital, or at least some ability to take care of the injured and the internally displaced persons. I'm not sure that Egypt will allow people from Gaza into its territory. There is a question of what is the legitimacy of not allowing that. I don't know if Israel will allow uninvolved civilians to go into the Negev region for a field hospital or a temporary camp. I actually don't know even if the people from Gaza would like to go into the Negev or not. There is a question of what happens on the ground, but definitely Israel should allow more humanitarian aid into the south of Gaza. And to some extent, I'm guessing here, but I'm assuming that at some point Israel will also allow fuel to enter into the south of Gaza in order to make sure that hospitals can operate, the generators can operate. But in the long run, the goal, or at least the official goal, is to avoid and minimize the harm to the civilians. But at the end of the day, if Israel is asking to evacuate Shifa Hospital, and you have people there that are injured and ill and are unable, it's not feasible for them to move, there's a question of how effective that warning is to begin with, but Israel has to do everything within its power to ensure that they will be able to go to a safe place and also ensure the safety of their transfer. And these are very difficult aspects because Hamas is not only trying to deny that corridor, it's also stopping from people from Gaza, uninvolved persons in Gaza, to move to the south, either by force or by shooting at the routes that allow them to go south, or just blocking them with buses or trucks, etc. And it causes a severe problem with the ability to take care of those uninvolved civilians. In the long run, I'm quite sure that we would rather see them all move and evacuate from that region, and then when things calm down, return and start to reconstruct the Gaza Strip. I see a question from Ben. Heaven forbid if members of the Hamas High Command embedded themselves with hostages in tunnels. In proportionality analysis, the hostages will have the same value as Palestinian civilians in any targeted decision. As always, the IDF could postpone or cancel attack, a point not yet discussed. Likewise, the IDF could always use less lethal weapons in tunnel warfare in an effort to protect hostages. Generally, I agree. Civilians are civilians. I would emphasize that Israel might generally have a bigger obligation towards its own, or towards the hostages, because it also have a right to life obligation from human rights perspective towards them because they are its citizens or residents in general. So there might be a higher, but definitely it doesn't mean that the protection of the civilians, the uninvolved civilians in the Gaza Strip, are under any level of the minimal threshold of protection of civilians. So the fact that even if they are uninvolved human shields does not, involuntary human shields, then they are not to be considered of a lesser value of a civilian, protected civilian, or civilians who are protected from direct attack, rather than any other civilian in the armed conflict. But I would maybe consider even a higher level of protection towards the hostages because of the human rights perspective of the right to life that Israel has towards the hostages. I hope that actually answers. I think cancel operations and yeah, it's always an option, but at the end of the day, in armed conflict, you didn't need to win the armed conflict, and just canceling all operation because of human shield situations, whether they are Palestinians or hostages, human shields would just provide an incentive to use more and more human shields. So that might be also counterproductive. And less lethal weapons, I'm sure that in the tunnels, especially because of the hostages, the IDF is very, very colorful. And the last things we would like to see as Israelis, but in general, would see hostages being harmed during an operation for their rescue. Yeah, I think our time is up. I think it was a very interesting talk for me. I hope it was just the same for you. I want to thank you all for coming. If you have any more questions or points of discussion, I gave you my email in the PowerPoint at the end of it. This video will be uploaded to the YouTube channels of both ALMA and the Minerva Center, which are quite easy to locate. And I do hope you enjoyed, and I wish you a pleasant and quiet day or evening. Thank you very much.